Higher Education Course 630. My name is Eric Roscoe. In this video, we're going to discuss the court case of Professor John McAdams versus Marquette University, and also why the legal issue of the case is or is not based on academic freedoms. Also reference an article that I found online by an author who is giving his own opinion about the court case. I found it easier to understand the court case by not only reading about it from a direct court analysis way, but also understanding outside opinions. So in 2014, a student was in a class and they were getting a list of topics that they were talking about, and on that list was gay rights. After the class, the student approached the professor, the instructor of the class, and started a conversation with them, and the topic of gay marriage came up. I'm not sure about the details, but some inappropriate comments or disrespectful comments under the understanding of the professor were made by the student, and the professor instructed the student not to ever repeat those kind of remarks, that those kind of remarks were not allowed in her class. And if the student was not happy with that decision, she could or he could freely transfer out of the class or withdraw. The student shared the experience with Professor John McAdams, and the student had also recorded the conversation. Professor John McAdams wrote about the encounter the student and the professor had on his personal blog, and in the same blog, he also included the instructor's personal website. The blog post started to gain steam, and people started to leave hateful comments on the instructor because of the encounter. The university got word of the situation, and Professor John McAdams was brought in, and there was a hearing, and the university professor decided to suspend the professor without pay, and that's where the court case begins. Now, the question whether or not the legal case is an issue of or is based on academic freedoms is yes and a no. So it's a no because it's not academic freedoms in regards to what the student was allowed or not allowed to say. That's not what the court case is specifically talking about. However, it is talking about the academic freedoms that a professor has, in this case, Professor John McAdams. So the court case has a lot to do with the fact that Professor John McAdams and his legal team believe that he was wrongfully terminated because of his blog post. So not only is it a case of about academic freedoms, but it's also a case about contract law, essentially, and this binding contract that the school has, that the university has with the professor. Now we understand what tenure is that professors of universities have the freedom to have their own opinion and write or talk about any opinion or any topic that they may without any repercussion. Now, I'll read the article that I found specifically in the National Review by an author named David French, who really sums up the correlation between the contract between Marquette University and Professor John McAdams, saying, if McAdams' blog post fit within the scope of protected academic expression, then the university was barred by the terms of its own faculty handbook from punishing McAdams for it. The handbook was crystal clear, and this is David French referencing the handbook of the university. In no case, however, shall discretionary cause for discipline be interpreted as to impair the full and free enjoyment of legitimate personal or academic freedoms of thought, doctrine, discourse, association, advocacy, or action. So I really wanted to reference that because I think that really ties in the reason why Marquette University ended up losing this court case to Professor John McAdams and ended up having to reinstate him and actually pay some money to him. Professor John McAdams was in his full right to blog, and even in his personal blog, and share any website with people that were reading his blog, considering that he is allowed to share his own personal opinions on things, specifically having to do with his opinion on how the teacher handled it well or handled it really bad, that a student had confronted him about gay marriage or gay rights. So this legal issue is definitely about academic freedoms, but specifically academic freedoms that were essentially the reason why Professor John McAdams was let go. So I hope that makes sense, and thank you.